Further hearing on the Queen on the application of Wright against Resilient Energy, Severndale Limited and another.
My Lords, returning to the Secretary of State's submissions, there are, just to give the heads up on what remains to be dealt with, there are 5 main points for me to deal with, and they're these. I want to give some illustrations of policy which are not concerned with the character of use of land and in the context of where we are today. Secondly, to look a little further at material considerations as a counterpoint, really, to any impression that we might have that we're limited to those matters. Thirdly, to then return to what Lord Scarman had to say in Westminster and Newbury. Fourthly, to pick up on my learned friend's question, Mr. Cameron posed quite rightly in my submission the question, can changes in planning policy have an influence on a material consideration, or can a policy make something material? That was the question he asked. And lastly, to finish off by looking at Regulation 122 and whether that should play any role in this case. So turning to that first point, we have, out of the door of the court, an area of regeneration. We have, as we see in Swansea, as we see in Bristol, Liverpool, we see regeneration around a dock. And what one has there is a mix of uses, commercial, housing, retail, and behind all of those schemes is a need to bring economic life back into an area which has moved on. And we see outside examples of what must have been important considerations so far as this area is concerned. And I want to pick up on 3. Firstly, the economy. Secondly, what sustainability is in the terms of the framework. And thirdly, housing. If we could turn up, please, the framework in Core Volume 3. Core Volume 3 has the framework starting, as we saw yesterday, at 862. And if we could turn in that to 873. 873 has paragraphs 18 and 19 of the framework. So we're in Core Volume 3. I do apologise. 1025, distracted by the multiple pagination. 1025, paragraphs 18 and 19. So those paragraphs set out what the government's approach is to economic growth, which is to build on the country's inherent strengths and be committed to securing economic growth. So far, so straightforward. Paragraph 19, committed to ensuring that the planning system does everything it can to support sustainable economic growth. We're told that planning should operate to encourage and not to act as an impediment to sustainable growth. That is, in that pair of policies, pair of paragraphs, a policy in respect of economic growth which we can see would necessarily be behind the sort of development which would be the regeneration of an area such as this. But what's interesting about it is that not only is it a material consideration within the framework, it actually goes so far as to give the Secretary of State's view as the weight to be given to it. And so we see in the last sentence of 19, significant weight will be given to. Those economic imperatives are not matters which are character, the use of land. They go further than that. To give another example along the same lines, if we think about the way in which this area is connected by transport, public transport means, Cardiff Central, Queen Street, one can see that the question of what is sustainable economic growth might play out here in the context of policies to do with what amounts to sustainable transport. And one could well imagine in a development such as Cardiff Bay, a contribution being made to improving the railway station. Likewise, one can see that that is founded in the policies in the framework which deal with sustainable travel. Not immediately connected to character of use. Those would, of course, be secured by 106 agreement and planning obligation. To turn to another example, the last example I would give, which is housing. In the mix of uses, we have housing. And paragraph 50 in the framework, staying in volume 1, turning forward to 1032. Paragraphs which we went to yesterday, paragraph 50, second bullet point as to tenure, and third bullet point as to identifying affordable housing need and setting policies for meeting such need. One sees in this locality housing and the building of flats is plainly something that changes the character of the use of land, but we don't know what the ownership is. It might be open market housing, it may be shared ownership, it may be some other form of affordable housing, but one has no idea from looking at the form of built development. And what that is doing is putting into effect a policy which seeks to meet a social need. It's a social question. And it is a policy which goes to the objective of avoiding neighbourhoods which segregate parts of society. Plainly a social objective and nothing else. So turning away from where we are now and picking up on the point which is really, in my submission, so important in the submissions that you've heard to date, the extent to which material considerations flow from the terms of the Act. I want to make it absolutely clear at the outset that very many of the policies which one finds in the framework, very many of the policies which we've had in other policy documents, have really clear links to the phrase change, or really clear links to the question of character of the use of the land. So, for example, there's a whole chapter on design in the framework. Evidently, Greenbelt policy goes to that question, the protection of areas of outstanding natural beauty. All of those happily fit with that sort of description. But there are others which are perhaps somewhat more debatable if one thinks about flood risk, the sequential placing of development away from places likely to flood. I can well see that that is probably arguable as relating to character, but it becomes rather less clear. But there are some areas which are areas of policy which are nothing to do at all with that question. Need is perhaps one of the best examples. We've had since at least 1980, I think Circular 9 of 1980, dealt with the 5-year land supply of housing land. So for all of that time we've had that policy. What does that policy do? It deals with planning from the point of view of identifying what the need is for a whole district and ensuring that the need is met, firstly by looking at what the population is going to be, looking at what the likely economic growth is going to be, and assessing the deliverability of the existing supply, and then coming to an assessment as to whether or not there is a 5-year land supply, and consequences flow from not having a 5-year land supply. The same point applies in respect of minerals, depending on the type of mineral, either a 7-year land bank or a 10-year land bank. What one has there are policies which are about the proper planning of a district, and they are policies about how planning decisions should be taken, but they are not at all concerned with the phrase which is at issue here.
Housing cases are all, as you say, whether you're at an inquiry concerned with the development plan itself, or you're dealing with a specific planning application, the whole point in looking at the housing land supply and whether sites are deliverable or not has to do with the use to be made of land. Typically, the developer will be arguing that there's an inadequate deliverable housing land supply, and therefore additional land or a site in which he has an interest should be allocated for housing, which currently might be allocated for industry or whatever, some alternative use.
My Lord, yes.
And of course, the inquiry is all concerned
yes.
with. It's not concerned with land immediately. It's concerned with statistics about household formation and population changes and the like, demographics, and then looking at all the sites that the planning officers have assessed as being deliverable and deciding whether or not they are in fact deliverable. But at the end of the day, the resultant decision will be about whether or not a particular area of land should be allocated for housing or not.
Well, if I may respectfully say so, an application having been made for operational development for housing will, as my Lord identifies, always result in an effect on the use of the land. I quite concede that. That is absolutely plain. But the question which I'm seeking to address is, well, if one is looking at planning policies, is there something more to planning policies in the modern context than solely that issue? And so I don't seek to persuade the court that there are no overlaps in this question. There plainly are. And as Mr. Cameron has submitted, one has the question of consequence, and what my Lord is articulating, if I may say so, is, well, that's the consequence. One has a development which has resulted in a change to the land. But the policy is something else, having regard to other planning purposes.
Well, the issue is always how to make the best use of the land in order to accomplish wider objectives, typically in terms of employment, transport, housing, and so forth.
Yes. And it is that exactly encapsulates the submission, that it's the question of the wider objectives. And so the wider objectives are certainly in play, whether one is looking at the question of need, whether one is looking at social questions in respect of the nature of housing to be provided, including its tenure. Those wider points, economy, society, environment, are alongside the ultimate question of, which will necessarily result, looking at what the change will be to the character of the land. So they are of a piece. They are both within the sphere of the government's planning policies, but they cannot possibly be said in my submission to all fit happily within the phrase that we're debating.
But if I may say so, your argument seems to be a rather different one, which is that a given policy, say an economic policy, might be a justification for a grant of planning permission, even though it's unrelated to the character of the use of the land. So, for example, if you want to bring prosperity to a community, you then, if that's the economic policy, it might be achievable by effectively taxing people who apply for, who are going, as a consideration for granting planning permission, and requiring them to I don't know, to pay money to the local authority to fund whatever it wanted to provide.
My Lord, I understand the way in which the example is given. My point is a somewhat different one. But in deciding whether or not to grant planning permission, there will be a planning balance struck. And part of that planning balance will include the matters which are said to be benefits. If there are economic benefits from a proposal, they will be, in my submission, relevant. They will be material considerations. And in my submission, that is a routine, day in, day out, material consideration. What is the employment which results from a particular proposal, either from its operation or in its construction? And so it would be commonplace to see an assessment of what the economic effect would be of the construction. And that in itself would play into a policy which is actively supporting economic growth, the provision of jobs. That may play into, one sees it on occasion, that may play into a planning obligation. If the proposal provides for economic growth, and that's relied upon as a benefit in the planning balance, it might be said, well, how do we know that this is going to provide for employment which is sufficiently local or in the place where the economic growth is needed? And it's not unusual to see in a planning obligation the need to have in place a scheme such that the employment provided from the scheme is derived from a particular locality or in a particular way. And so those sorts of things are secured. And that is really one of the ways in which planning obligations can function in order to secure benefits that are relied upon, because otherwise one can have a mere assertion that there is an economic benefit which will give local people employment, but then no means of actually putting that into practice and securing it. So in that way, it's rather different from the way in which my Lord put the question to me. There is a planning balance to be struck. What goes into the planning balance? Economy will be a factor. The provision of affordable housing. If there is a policy which says supply 30% affordable housing, and that policy is met and more in a particular proposal, supplying 40% affordable housing, then in the planning balance, then more weight might be given to that particular social outcome in the context of a particular need in a locality. That will go into a planning balance against which may be all sorts of negatives arising from the impact of the proposal. And it is in that way that planning decisions are, by both the Secretary of State and by planning authorities, decided routinely. And in my submission, those sorts of considerations do not sit happily with the phrase that we're considering. Can I turn to slightly tangential, but in the topic of material considerations, I just want to pick up on this further example of a material consideration, just so that we have in mind the broad scope of material considerations in planning decisions. And that's just to mention the question of precedent. And so to the extent that there is or a series of, for example, Secretary of State decisions on a particular issue, those will be material considerations themselves. That takes us in a slightly different direction, but I only mention it just to flag the substantial range of material considerations which may crop up in any particular case. My lady, my lords, that completes what I have to say on the second matter. I want to turn now to the law again and to consider some of those points in the context of what we have seen said by Lord Scarman in Westminster and Newbury. So if we could take up, please, the authorities bundle and turn, please, to turn, please, to Westminster, first of all, at tab 22. So we're in Westminster City Council and Great Portland Estates. And if we could turn, please, in that to page 670, and to the passage that we've been referred to in particular. I do apologise. That's the second time I've managed to get it wrong. 1752.
Have you given us the electronic page number, please?
I think I have. 1752 is the electronic page number. I
Thank you very much
Melody.
indeed. Thank you.
We've been directed to that paragraph, which is between C and E, and the reference there to serving a planning purpose and that relating to the character of the use of the land. Just wanted to explore that a little in the context of what, two points really, in the context of what was at issue here, because we have here a case which has moved on from the countryside, which we've seen in Fawcett and the Barnett case, and we're here in the urban area, and we're looking at a particular policy concerned with central London in the context of whether or not it was appropriate that it goes into the plan. And what we see across the page at the top of 1753 is what was said at first instance about the policy in issue. And so Wolfe J, as he then was, is cited. The plan doesn't fall foul of the statement by Lord Parker, Chief Justice in East Barnet. It contains provisions designed to assist the position of a particular class of user of property, which is in the policy of the City of Westminster for planning reasons to encourage to remain in the city. And at C, Lord Scarman has no hesitation in accepting the view of the judge. What is being considered there, in particular, is paragraph 1126 of the plan which was at issue. And if we could go back, my lady, my lords, if we could go back to 1751, we see from the plan the key paragraph which was being discussed, 1126. And this is the explanation of the policy. This is concerned with industrial uses which are considered important to the diverse character, vitality and functioning of Westminster. Referring to 1121, and planning permission for major rehabilitation or the redevelopment of industrial premises containing industrial use will not normally be granted, where it's considered that such development could be to the disadvantage of existing or potential industrial activities. And we know what they are from the previous page, and so towards the top of 1750 at B, they're set out for us in the extract from 1123. The greater proportion of this floor space is occupied by firms dealing with clothing, fur and leather, paper, printing and publishing. So what's at issue here, we see at the end of that paragraph, the City Council feels that the loss of these supporting activities may threaten the viability of other important central London activities. It's not concerned with what in planning terms is a use, we're going to protect this particular use class, this particular industrial use class. It's concerned with particular activities found to be unobjectionable. And so that really is moving on a little, but in my submission we learn a little more about what Lord Scarman was saying about this test when we go back to Newbury. So if we can go back, please, to Newbury in the same volume in tab 12, where we find at 1489, within the speech of Lord Scarman, he's there dealing with the validity of condition point, and at H, in that last paragraph, he records Count Sell's elucidation of the three tests, the first of which is that the condition must fairly and reasonably relate to the provisions of the development plan and to planning considerations affecting the land. Over the page, at top of 1490, between A and B, that submission by the Appellant Counsel is accepted. Lord Scarman goes on the same page, between F and G, to integrate that conclusion with what had been said previously in Fawcett's case. And so within the middle of the paragraph there is a sentence which starts, "In Fawcett's case, this house," and goes on to say, in effect, adopted three tests, and sets out for us, as had been submitted by the Appellant's Counsel, Mr. McGarry, Queen's Counsel, whether the scope of the condition was unrelated to the policy declared in the outline plan or to any other sensible planning policy. So the short points which come from that exploration of those two authorities is that, in this case, a condition is valid by reference to relevant matters which include the policy and the development plan, and likewise it must follow that policy in the NPPF, the framework, is likewise evidently such a matter. And I next submit that in neither case was Lord Scarman limiting the scope of relevant matters to the character of the use of the land, rather expressly referring to exceptions, and made a finding on the facts of those cases which admitted of a policy which was adopted for good planning reasons. So before turning to Mr. Cameron's question, my fourth matter, I just want to cover off one point from the Secretary of State's case, paragraph 22. So if we could turn away from the authorities bundle, my lords, if we could turn please to core volume 1 and to the Secretary of State's written case. Paragraph 22 can be found on pages 138 and 139.
By my calculation, you have 2 minutes left, but
I shall use them wisely.
please do.
The question has arisen as to or and, or which of those should be in this sentence. My lady, it's or, because if we think of circumstances such as East Barnet, all that's in play in that case is a question of intensification of use. Is that a material change of use? That's not a planning policy question at all. It's an application of the terms of the Act, looking at the facts of the particular case. So one needs both. Which brings me to Mr. Cameron's first question. Simply this reassurance on the question of whether or not a policy can realistically become something which turn something which is immaterial into something which is material. There are 4 protections in that regard in the development plan process. Firstly, 2 consultations on a policy by a planning authority. Secondly, an obligation for a planning authority to submit what they consider to be a sound plan, including legally compliant. Thirdly, that the Secretary of State would have to conclude that such a policy conformed with the framework and was legally compliant in order to recommend that such a plan would be adopted. And fourthly, there is access to the court for anybody who wishes to object to the legality of a policy. And so, lastly, my lady, this. The third element of my submissions is set out in the written case to explain that the Secretary of State invites the court to consider Regulation 122 in the context of what we've seen in this case. I don't understand that to be controversial, but alongside that, the Secretary of State wishes to make very clear that the long-established principle, which is captured in paragraph 44 of Aberdeen, cannot buy planning permission or require inappropriate contributions. That which is captured in paragraph 44 has a long heritage of support in this court, and if we were to explore the policy position over a period of time, we would see that the Secretary of State is likewise very much attached to that exact same policy, and so that is expressly endorsed. So, my lady, that concludes my submissions in a case which is essentially about the appropriate relationship between a number of principles and the way in which they can be appropriately codified, and the Secretary of State makes those submissions accordingly, having regard to the case law, the policy, and where we are now with Regulation 122.
Thank you, Mr. Kimblin.
Thank you.
It's always very helpful to have the Secretary of State's view on matters such as this. Whether we agree with them or not, it's always very helpful. Thank you.
And the Secretary of State is equally grateful for the opportunity.
My Lady, my Lords, first of all, the proper approach to the construction of the Act and the phrase material considerations. The respondent's submissions do not contend that the Act and the references to material considerations is not to be interpreted as a living statute. At the same time, the respondents do not admit the relevance of planning policy in the definition of what are material considerations. Planning policy, as we made plain in our main submissions, is the main way in which government influences planning decisions across a broad range of considerations. You'll recollect the paragraph 140 from the Auckland decision, the reference to social, environmental and economic considerations. The formulation of the policy is one of the main ways in which government gives effect to changing societal expectations as to what will be relevant in the context of planning decisions. Planning policy has long been established as a material consideration in planning decisions. You can see that set out in the framework which we're considering, Core Volume 3, and at page 1020. And at page 1020, paragraph 2 of the framework, planning law requires that applications for planning permission must be determined in accordance with the development plan unless material considerations indicate otherwise. The National Planning Policy Framework must be taken into account in the preparation of local and neighbourhood plans and is a material consideration in planning decisions. And then a reference to EU law. So the Secretary of State's position starts from a situation in which he has formulated a planning policy framework which he is regarding as a material consideration, supported by many decisions of the court, that such policy is a material consideration. It's material because it addresses matters which are, taken in one way or another, bearing on the character of the use of the land. Subject to any challenge to the lawfulness of the policy, it stands as a material consideration lawfully to be taken into account. The respondents contend that, that only land use or planning considerations that are relevant or related to the character of the use of the land are material. They rely on the decisions of the House of Lords in Newbury and Great Portland. It's important, however, to see where those have come from, and you've just been reminded of the East Barnet decision and its role. Could I invite you, please, to turn up East Barnet, that's the authorities bundle, the primary bundle, at tab 6, and the bundle page is 1298. And at 1298, something which has been referred to from the middle of the page, but above that reference in the middle of the page and 4 lines down, you'll see a sentence starting, the question immediately arises as to what meaning one attaches to a purpose different. Is the general purpose considered, or is it necessary to descend to the particular and consider whether the particular purpose was different? To take an example, is the purpose for which a shop is occupied and the purpose of a retail shop quite generally, or is it the narrower purpose of being used as a retail shop for the sale of a particular commodity? If the former is correct, then a change in the nature of the article sold would not be development, if the latter it would. And you can see how Lord Parker went on to address that. And then at page 1299, in quoting with approval what was being said by Mr. Justice Glyn Jones in Marshall and the Nottingham Corporation, and that's starting at the bottom of 1298. But on 1299, in the long quotation, about a third of the way down the page, you'll see a sentence starting, moreover, if the business of a retail dealer is being carried on in any building, maybe there's a change of use if, for example, the business of a baker is substituted for a different business, for example, that of a grocer. But I'm unable to see why or how such a change can be material from any point of view which could legitimately be taken by a planning authority. So making it quite clear that it's not what's being sold in the shop that matters, it's the fact that it's a shop. That's the character of the use of the land. As our references to other cases have indicated, a different view has been taken subsequently. A different view, the explanation for which is that in those later cases, the court was taking into account relevant policy from the Secretary of State in the main, relevant policy, and reflecting on the impact of that policy on the character of the use of the land. And so that simple formulation in East Barnet has not been apt to prevent the court as regarding as material whether or not a shop sold unhealthy food in a location proximate to a school. The court did not say, notwithstanding the express invitation to do so, did not say that, no, that's nothing to do with the character of the use of the land. So, my lady, my lords, we make these propositions. What relates to the character of the use of the land is not to be interpreted in a way which excludes reflecting relevant planning policy. Nor is it to be interpreted in a way which is limited to merely physical land use planning issues. And I reference there Fawcett, Mitchell and Copeland, all three authorities that we've referred to already, and I'll come back to in just a moment with a slightly fuller explanation. Secondly, the flexibility in the approach adopted means that the phrase, the character of the use of the land, is a somewhat protean concept. De Smith, and you've got the extract in the authorities bundle at tab 23, and I referred to it yesterday. I make it clear I adhere to the position adopted by De Smith as part of my submissions. De Smith is right when it said that what is material responds to what planners are doing on the ground. If it were not so, then the decisions that I've referred to a moment ago would have been different. Importantly, in each of those cases, policy properly influenced the position. So I take them in turn. First of all, Fawcett. The question of whether a cottage, used, of course, for residential land purposes, that was the character of the use of the land, was a home, was occupied on the one hand by an agricultural worker, on the other hand by an office worker, was considered to be a relevant planning matter, thus a matter bearing on the character of the use of the land. The respondents do not suggest that the outcome was anything other than an application of the policy related to the protection of the Greenbelt. And my lady, my lord, saw the reference to the policy. You'll find the reference to the Greenbelt policy in Fawcett, pages 1346 and 1352 and 3. And I remind you again of what Lord Jenkins said at 1355, which we saw yesterday, but Lord Jenkins was quite explicit in the passage we referred to at the bottom of page 1355. Accordingly, the power must be construed as limited to the imposition of conditions with respect to matters relevant or reasonably capable of being regarded as relevant to the implementation of planning policy. So what made the difference in Fawcett was not the character of the use of the land, because the character of the use of the land didn't change from residential to something else. It remained residential. What changed was, and what made the difference, was the application of a policy. And then Mitchell, the question of whether a house, and again, a residential land use, was occupied on the one hand by an impecunious resident or on the other by a market buyer, was considered to be a relevant planning matter, thus bearing on the character of the use of the land, having regard to planning policy guidance that was then in play, addressing the needs of those less able to afford their own home. The head note sums up the position, and Lord Justice Balcombe was explicit in drawing attention to the relevance of policy. My lords, you can see that in the Primary Authorities volume. It's at tab 11. The head note is at 1443. If I can invite you just to look at the bottom of 1443, the reference to the Planning Policy Guidance Note 3, and turn, if you would, then to 1447, and Lord Justice Balcombe. In my judgment, it's unrealistic to say that economic considerations do not relate to the character or use of land. I refer to the document entitled PPG 3, issued by the Secretary of State, paragraph 38 of which, under the heading Affordable Housing, says, communities' need for affordable housing is a material planning consideration which may properly be taken into account in formulating development plan policies. Paragraph 4 of the consultation paper of January 1993 develops that by saying, in my judgment, those provisions recognise correctly that the density of permitted development and so on. So what made the difference in Mitchell? Not the character of the use of the land. The character of the use of the land was always residential. What made the difference was the application of a policy which was directed towards social considerations, see Alconbury, paragraph 140, social considerations related to making land, I beg your pardon, homes available for people who would otherwise not be able to afford them. And then Copeland, the question of whether a takeaway shop near a school was occupied on the one hand by a fast food purveyor, or on the other hand by a purveyor of something healthy in the form, for example, of salads, was considered to be a relevant planning matter, thus bearing on the character of the use of the land, and again influenced by policy considerations. The policy considerations in that case, my lords can see at tab 16, bundle page 1552. Actually, we might just start at 1550 in the light of the submissions that have been made. 1550 at paragraph 14, Mr. Justice Cranston quotes what the council was writing, and you can see the reference there to Great Portland Estates and reference to the character of the use of land and all that being advanced. Paragraph 15 highlights a response that was given by the claimant's solicitor, referring to healthy weight, healthy lives. Challenging sort of title, but in 2008, no doubt ahead of its time somewhat, but over the page then, if you could see paragraphs 22 to 24, promoting social objectives may be a material consideration in the planning context. Planning controls in order to promote social objectives are considerations which can relate to physical land use. Whether a social objective is relevant in a particular case turns on the circumstances. As long as the promotion of the social goal is lawfully within the planning sphere, it matters not that it falls anywhere else as well. Then a reference to well-known authority of Stringer, and then after that, reference to the government's policy statement 1, delivering sustainable development, referring to, among other things, personal well-being, the need for planning authorities to seek to achieve outcomes which enable social, environmental and economic objectives to be affected together. What's making the difference is not any difference between the nature of the use, selling food from a shop. What's making the difference is the application of a policy which says we wish you to eat healthily, we wish children to eat healthily, and accordingly we shall take account of those healthy eating considerations and the policies directed to them in the exercise of planning controls. In this case, there is a relevant land use policy. It is to be found in the planning policy framework at paragraph 97. That's in the authorities bundle at 815, and the court's been referred to it already. And also in the national planning policy guidance in the authorities bundle at 1859. That policy draws a distinction between a wind turbine development operated or led by the community and a wind turbine development that is not operated or led by the community, or which does not have evidence of community involvement. The respondents do not suggest that these are not land use planning policies. No part of the submissions made to you is that the Secretary of State's gone astray and his policies have gone outside what's relevant to land use planning. There are, of course, regularly challenges to the lawfulness of policy, both to national policy and in development plans. No such challenge is brought here. So the court starts from a position that there is a lawful land use policy in place that is engaging with the character of the use of the land, and it should, I respectfully submit, be astute to prevent any backdoor challenge to the lawfulness of what's being said. So our submission is that what is in the policy is a material consideration that relates to the character of the use of land. That makes material, firstly, community involvement and leadership, and you can see that reflected both in the framework and the planning policy guidance, and also makes material evidence of positive local benefits, that taken from the planning policy guidance, which we've referred to. Here, the progression of those issues and how they influence the planning process can be taken in the following way. For the first reference, we need core volume 1. And page 60. Which is in the Statement of Facts and Issues. And at the bottom of page 60 is paragraph 15, which is an extract from the environmental report. Bottom of page 60, extract from the environmental report, reference to the planning guidance. Guidance strongly suggests the need for more locally led renewables development, clearly recognise the benefits of such approaches by indicating that positive weight may be given in decision making. Then on page 61, reference to community initiatives being prayed in aid, reference to, in the bold text in the second paragraph, local planning authorities may wish to establish policies which give positive weight to initiatives which have clear evidence of local community involvement and leadership, and a reference to the Resilient Energy Severndale proposal. And you can see clearly from that that here are the first appellants praying in aid, very clearly what is being said in the policy in support of their proposal. And environmental report, of course, a part of what needed to be taken into account. Secondly, the applicant's letter of the 7th of August, which is in core volume 3, at page 859, and if you look at the letter, you'll see it's a letter of the 7th of August, written on behalf of the applicants for planning permission, deals with numbers of supporters. Over the page, a consideration of the public benefits of the proposal, a reference to the new planning practice guidance, and the role of local communities. Bottom of the page, the legal structure which guarantees community benefits society being prayed in aid, and the concluding remarks, again drawing on the same material, adopting the same approach, drawing attention to community involvement and engagement and the benefits that the positive community benefits, to quote the planning policy guidance, that would be rolled out by this proposal. Thirdly, in the process, so there's an application document, there's a letter written after the application furthering the proposal, and thirdly comes the officer report update, the officers of the council's update report. My own friend said yesterday that there was no evidence of that the link to the policy was taken into account in the determination of the application. I respectfully disagree for this reason. If you take up volume 3 and go to page 864, I beg your pardon, perhaps as well, to just check at 862, there should be a note at the top of 862, update to officers' report. So that's what we're dealing with. So this is a report which, based on firmly established legal principles, we can take it that the members took into account in reaching their decision. And if you go to 864, at the bottom of the page, you'll see it deals with a different scheme. The last paragraph of the update related to this scheme. In conclusion, the benefits of the scheme in terms of the provision of renewable energy and being a community-led initiative weigh in favour of the development. However, in this case, it's not considered these benefits and so on. So there's no doubt at all that advice was given that what weighed in favour of the scheme was that policy-driven objective related to community involvement being a community initiative. So we've done the application, letter in support, the officer's report to members, then we get to the planning permission itself, and still in volume 3, if we look to see what reason was given for the imposition of the condition, and go to page 931, I hope on page 931 you find condition 28, which is the condition, of course, that we've been talking about. And I invite the court to note the reason for the imposition of the condition. And you'll recollect from our reading of Fawcett that the reason for the imposition of the condition featured somewhat there in the court's consideration of the matter. Well, here the reason is to ensure the project delivers social, environmental and economic benefits for the communities of Tiddenham and the broader Forest of Dean. I respectfully submit that is a clear indication that the reason for the condition being imposed was that it was intended the development should be firmly linked to and be a reflection of the policy, lawful land use policy, contained in paragraph 97 and in the planning practice guidance. For reasons I understand, my learned friend drew attention to the First Appellant's High Court pleading and its separation of the Community Benefit Society and the Community Benefit Fund. I've said before, but I make clear, I didn't draft the pleading, and in my view it's wrong. It's wrong because it doesn't reflect the way in which the application was ultimately progressed to committee, which was through a Community Benefit Society. It's quite clear that at earlier stages the fund was separate in the sense that the development was not going to be carried out by a community benefit society where all of the money would have gone to the community, would go to the community in any event. The respondents then complain about the Community Benefit Fund. They do so by reference to it having been regarded as something separate at the early stages of the application in the way that I've just referred to. There was no requirement that such a fund should be provided for in the grant of the planning permission, and that reflecting the fact that the Community Benefit Society mechanism was being put in place. You can see what condition 28 says, and I said in opening there was no separate requirement that there should be set up in any way a community benefit fund. The respondent's approach doesn't take account of the way in which the proposal progressed to one to be implemented as a community benefit society where all of the funds generated had to benefit the community. And that is, I respectfully submit, to be characterised as a positive local benefit of a kind encouraged by the framework and the National Planning Policy Guidance. The Community Benefit Society is, in essence, the means by which the policies in paragraph 97 of the framework and in the Planning Policy Guidance are, to borrow Lord Cohen's wording from Fawcett, are being effectuated. And it might just be worth seeing how Lord Cohen put that, because it neatly encapsulates an approach which is still, we submit, appropriate today. So we're in the authorities volume at tab 7 and at page 1331. You'll see at the top of 1331, Lord Cohen is clearly engaging with, fourth line, engaging with what are planning purposes, and then after the reference to Wednesbury and the end of the quotation, in that case, the Lordship's concerned with the policy of the local authority. In the present case, it would perhaps be more accurate to say that what the House is concerned with is not planning policy, but the means of effectuating a policy predetermined. And that's what, with respect, we are here concerned with. Here is the policy predetermined in paragraph 97 and in the planning policy guidance. What this case is about is the effectuation of that policy and whether that effectuation is lawful. And whether it's lawful, as the three decisions I referred to earlier demonstrate, whether it's lawful is to be judged in the context of the policy. So policy bears on lawfulness, policy bears on materiality in an entirely appropriate way in those circumstances. Lord Cohen continued in support of the second alleged ground, and there we have the reference which I've already picked up. He said the scope of the condition, so materiality, unrelated to policy declared in the outline plan or to any other sensible policy. The fact that among the benefits taken into account was the Community Benefit Fund does not address the point that the proposal is required to be delivered by means of a community benefit society. And that fact, of course, specifically responds to a legitimate policy. It is an inevitable consequence that all the profits and surpluses here will be used for a positive benefit for the community. The Community Benefit Fund, in that sense, adds nothing to what will be delivered by the Community Benefit Society development. The policy values community involvement and thus the operation by a Community Benefit Society in itself. I remind the Court, we saw it yesterday, I won't turn to it unless you'd like me to, but the benefits are not required to address any particular impacts. We saw that yesterday from Lord Justice Hoffman in Plymouth at 14 and page 1525. They simply reflect the benefits, that is, the effectuation of the policy objective, and deliver just what the policy wants in a way that is as much to do with the character of the use of the land as was the condition enforced or the other examples we've given in Copeland and Mitchell. The Community Benefit Society and energy and planning policy, the Community Benefit Society model and energy and planning policy happily combine in the approach that you can see set out in the DEC guidance, which is in the additional papers. That's the guidance which, as we looked at it yesterday, you'll recollect appropriately reflects the concern that these matters should be being undertaken in a way which has positive benefits for the community. Remember the DEC guidance additional papers, tab 48, 2265. And the references to a community benefit society operating for the benefit of the community. That's in response to the second, we want the project to benefit the community. And then in response to, we want to be able to distribute profits, page 2267, the right-hand column. CBSs are not allowed to distribute profits, dividends, or other surpluses. In essence, everything must go to the community. And a reference to the asset lock, which the asset lock simply prevents a society giving away any of its assets other than either to another community benefit society or to something else which will benefit the community. And in most instances, there is an asset lock. It's statutorily provided for. And then the same point with regard to issuing share capital, the very strict control to ensure that it's the community that benefits rather than shareholders. So what the shareholders, or I beg your pardon, what the investors get is to be limited to the essentially to the bare minimum to get them to put their money in the first place. In those circumstances, it's not surprising that the respondents don't submit that the fact that the development is to be implemented by a community benefit society is not a material consideration. If it is, and if it will get all of the surplus to spend on the community as it pleases, then, with great respect, the point about the community benefit fund itself is nothing to the point. There is, we submit, no danger in this approach that will lead to the buying and selling of planning permissions, said to be what the materiality question guards against, unless it is to be said, of course, that government policy being given effect to in this way, directly given effect to in this way, is going to produce such a result. I move then from those matters to just two additional matters. The first, the question of, is this a commercial form of development? And you'll, my lady, my lord, will recollect that the Court of Appeal took the view that really this was something which couldn't be distinguished from a commercial form of development. And the respondent's position set out in their case, I gave you two examples, paragraph 5, paragraph 62 is perhaps the best one. The respondent's position, paragraph 62, this is a commercial form of development. Yesterday, the submission, Delphic, if I may say so, the submission was, it's not entirely non-commercial. Not entirely non-commercial. Now, no friend will forgive me, and it's not intended to be unkind, but that is really another way of saying this is not a commercial development. And as a matter, if I can risk a reference to common sense, as a matter of common sense, reading the DEC guidance, reading the FCA guidance, the section 5 that we provided you with in the additional papers, it's very difficult, I respectfully submit, to reach any other conclusion, but this is very far removed from anything which could be described as commercial in character. It is fundamentally not commercial. It is fundamentally driven by what it can derive from paragraph 97 of the framework and from the planning policy guidance. That is the desire to benefit the community. That's what the condition was imposed to do, see the reason. That's what the policy aims to achieve. That's what would be achieved by this development being undertaken. Then finally, the source or the target, the way the money is spent. The respondents focus on what the money is spent on. That we submit, and have submitted already, is a wrong approach that leads to what we suggest is the absurdity of chasing every pound distributed to see what it's spent on. What matters, we respectfully submit, is whether the development as proposed will effectuate the lawful policy which is focused on community involvement and positive local benefits. If it does, the fact that the money might be spent on non-land use planning matters is nothing to the point. It delivers what the policy seeks in a way which is precisely and completely aligned with a lawful policy to which effect should be given, we respectfully submit. My lady, my lords, those are our submissions in reply.
It looks as if nobody's got anything to throw at you. I'm sorry about that.
Well, I won't express any disappointment again, but unless I can help you further, those are our submissions.
Well, we're very grateful to everybody for their submissions and for the economy with which they have been presented. And we will now go away and see if we can work out what we think the answer may be and let you know in the usual fashion in due course. Thank you.